And welcome back, students. Today we're going to be diving into our focus on copyright and some other legal stuffs. So let's first start off with copyright. So copyright is the exclusive legal right given to a creator of an original work to decide how their literary, artistic, or musical work may be used by others. Now note that copyright is not absolute. Right? It's not like set in stone, as they are subject to things such as fair use. Now, copyright only protects the expression of ideas. It doesn't actually do anything to the idea itself. Same thing would go like if you were looking at trademarks and stuff like that. You can't copyright or trademark an idea, um, but you can, do it with like the implementation, the expression of said idea. Now, depending on the country, copyright typically lasts from about 50 to 100 years after the death of the creator. In the U.S., it's about 70 years after the death of the author, unless it was work for hire, in which case it's 120 years after creation or 95 after publication, depending on which comes first. All right, now obviously we want to know how this is all coming back to technology. Well, the development of digital media and computer technologies have influenced and introduced new difficulties in enforcing copyright, because obviously it's really easy. You just throw something up on the internet, you can share it off. There's lots of collaboration tools out there, so it does make it a lot more difficult to enforce traditional copyright. So there's all these new kind of challenges that have been introduced to the philosophical basis of copyright law, because before it was printed, well, now it's in digital form, it's a lot easier to distribute. It's not just like, well, if just somebody made a book, well, it's easy to track down where the book was printed and stuff like that. Well, now I guess you can kind of still figure out where something originated, but because it's how easily it is for someone else to get a copy of it and redistribute it themselves, makes it a lot harder to really track down where this is all going. Now, businesses with great economic dependence upon copyright, such as the music industry, have advocated for the extension and expansion of copyright and have sought legal and technical enforcement. We kind of mentioned this a little bit when we talked about like Napster, and there was the development of the MP3, and there was all the file sharing stuff. The RCAA, which was the Record Company Association of America, decided, hey, we're going to go after people. Of course, that didn't really work out very well because when Napster got shut down, other file sharing services just popped up right after it. So it didn't really, kind of do much in that aspect because that's the nature of the internet. Right. Also, you have private companies such as Twitter will place in their terms an agreement that grants the platform provider beforehand a right to co-use all uploaded content. So this gets back to that piece when we talked about like privacy, like who's actually owning your information that you're putting up there. When you do tweets, let's say, for example, if you're using Twitter, or if you're sharing an image or something like that. Now, one technically, I guess you could argue, good thing is that the copyrights that are in that agreement only technically exist between you and the firm that's operating the platform. So, like when you upload something to Twitter, you authorize Twitter to use the image. You haven't necessarily authorized Facebook to use that image. So that's one thing to kind of note about that. Private companies in general do not recognize the exceptions or give users more rights than the right to use the platform according to certain rules. What are the terms and conditions is what they expect you to follow. So you actually have, in some ways, less legal rights through online platforms than you would in a printed version of those same applications. All right, now we're going to talk about Creative Commons because obviously we're dealing with digital media here, and so it's good to know about these different types. Now, Creative Commons is not simply just one thing. It's actually several public copyright licenses that enables the free distribution of an otherwise copyrighted work. So this is how we can tie this in with copyright. Copyright, obviously, somebody owns it, but with Creative Commons, we can kind of get around that. A Creative Commons license is used when the author wants to give people the right to share, use, and build upon a work they've created. So they want people to have access to it without pretty much having to shell tons of money to use it. Creative Commons also provides an author flexibility, such as only non-commercial uses of their work. And it also protects the people who use the Creative Commons work to use it or redistribute it from the concerns of copyright infringement. So as long as they're abiding by the conditions that are specified in the license, the people can use whatever the original work is freely and have no problems or qualms with it. So it's kind of one of those nice workarounds that they can get into. All right, now Creative Commons licenses have 4 conditions generally. Each of these are shown below. We have attribution, we have share alike, we have non-commercial, and no derivative. So an attribution is simply where the licensees may copy, distribute, display, perform the work, or make derivative works or remixes based upon only if they give the author credits in the manner specified. So you'll see, attribution is one of the 4 rights that falls into with Creative Commons. The next one is share alike. Share alike says that licensees may distribute derivative works only under a license identical to the license that governs the original work. So, for example, when we look at the next page, if the license is public domain, well, then it has to be pretty much public domain. Now, it can't be more restrictive. So I can't start with a public domain work and restrict it to a lower level license. So then we have non-commercial, which are when licensees may copy, distribute, display, perform the work, or make derivative works and remix. This is based only on non-commercial purposes. Now, this can't sell it for money. Right? That's the easy one to remember. Non-commercial means you can't sell it for money. And no derivative works. Those licensees may copy, distribute, display, or perform only verbatim copies of works, not derivative works or remixes upon it. This is a lot we'll see something that's maybe more software kind of based, or if you want people to use maybe some audio or video or document, something like that. But you only want them to have and use the original. You don't want them making additional copies of it and modifying it to their own extent. So that's where no derivative comes from. All right, these are the 7 types of regular use licenses with the Creative Commons. You, of course, have public domain. And as we look through these, they're going from least restrictive to more restrictive. All right, so public domain is the least restrictive. This is probably the best license to have for works because it's, bringing content globally without restrictions in the acronym CC0. So public domain, free to use. And we'll talk a little more about that in a second here. Then you have attribution alone. All right, attribution alone pretty much just says you can do whatever you want with this work. All you need to do is just attribute it back to the original author. That's all. Attribution plus share alike. Okay, again, attribute to the original author. And if we look back at share alike, it says that they have to use a license identical, not more restrictive, that governs the original work. So, because it can't be more restrictive, we can't go down this chart. So with the share alike license here, it could fall here. Like when I make the new work, it could technically be attribution alone public domain. Right? Then we have attribution plus non-commercial. So in other words, you have to attribute the author and can't sell for profit. Attribution non-commercial plus share alike. So that's combining everything above. Attribution plus no derivatives. All right, so you have to contribute to the original author and you can't modify it. And attribution plus non-commercial plus no derivatives. So this is the most restrictive right here. Pretty much you have to attribute the original author, you can't sell it for a profit, and you can't make a derivation of it, so you can't modify it. All right, so let's just talk about those Creative Commons rights here. So aside from public domain, right, all current licenses are going to require the following things. So any copyright notices. If the work itself contains any copyright notices placed there by the copyright holder, those notices have to be either left intact or you have to reproduce it in some manner. So if it was like copyright 2018 to some organization, then you need to leave on there copyright 2018 some organization. You also have to cite the author's name if the work is published on the internet, which pretty much all these things are going to be. A link to the name or profile page if the page exists. It could be whatever the person's name is, but if they have a website, you probably want to link it back to that. You want to cite the work's title or name. So if it was like, let's say, a big meme and you went and made this meme, then you went and said, hey, I'm going to use some derivation of this. Well, they're saying that if the work is published, then you need to link back the name or the title to the original work. Additionally, you want to cite the specific Creative Commons license the work is under. So whether that is going to be public domain, it's going to be attribution only. It just depends on what it is. Also, you need to mention the work is either derivative or an adaptation. So in addition to the above, identify if the work is a derivative work. So if you made those modifications, just note that. Now, that aside, let's go ahead and look at public domain, which is probably the best one to have because, again, public domain has no restrictions, so you don't have to worry about using it in certain things. So public domain consists of all the creative works to which no exclusive intellectual property rights apply. Hooray for public domain, it's great. All right, these rights are typically ones that have either expired, been forfeited, expressly waived. People say, I'm not interested, I want to put it right in the public domain, or they may be inapplicable. All right, so like remember ideas, for example, you can't copyright those, so they're automatically in the public domain. Here's some quick examples like the works of Shakespeare, Beethoven, early silent films, etc. These are all in public domain, typically by the virtue of either been created long before copyright law was written or by their copyright term having since expired, because copyright law in its current form is a lot longer after the death of the author. It used to be a lot shorter duration, and they've just gradually increased it over time. Now, some works, of course, are not covered by copyright, as we mentioned, like ideas, and therefore they're automatically in public domain. So, like formula, Newtonian physics, cooking recipes, and pretty much all computer software prior to 1974. Because after 1974, guess what programming language came out? C. And so they started actually copyrighting their software applications then. So you had a big shift in paradigm of software development as well during that time. But let's talk about fair use, because remember, copyright has an exception to it, which is that of fair use. Now, fair use is a doctrinal law in the U.S. that permits limited use of copyright material without having to first acquire permission from the copyright holder. So, that's like, when teachers want to make a copy of something, they using fair use. They don't have to contact the copyright holder every time that they want to make a copy because it falls under fair use. All right, fair use is one of the limitations to copyright intended to balance the interests of copyright holders with the public interest in the wide distribution and use of creative works by allowing as a defense to copyright infringement claims certain limited uses that might otherwise be considered infringement, like I just mentioned, making a copy. All right, so some examples of fair use in the U.S. copyright law include things such as commentary, search engines, criticism, parody, news reporting, research, and scholarship stuff. So, search engines, obviously you're going to see stuff pop up in search engines that might be considered copyright. Fair use because the search engines are simply there to help navigate. Commentary is a big one because, if we're talking social commentary, video game commentary, sports commentary, whatever. That all falls under fair use. Same thing with criticism and parody because it's a derivative of the original work. You're not trying to pass it off as your own. News reporting, obviously, because a lot of times news is not necessarily done by the organization that's reporting it. It's done by maybe a sister station or a local station they're picking up and they're simply just reporting it. And also research and scholarship is kind of self-explanatory because it's for educational use. Now, fair use provides legal unconditional citation or unlicensed, or incorporation of copyright material in another author's work under a four-factor test. So these are the four factors that you have to pass for it to be considered fair use. First is the purpose and character of the use. Right? Whether the use is of a commercial nature or is for nonprofit educational uses. All right, obviously, nonprofit educational, you're much more likely to not get dinged for violation of fair use. Nature of the copyright work, whether certain aspects such as fiction or not fiction are relevant to that. The amount and sustainability, whether the less or more of the work have been used in relation to the whole of the work. So pretty much the less copies you're making of something or the less you're doing it of the same thing, means that it's probably going to be more on the side where you're not in violation of copyright law. And of course, the effect upon the original work value. What effect has the infringing use upon the original's value? So when you make that parody of something, is it ultimately affecting the original brand? All right, and that's going to wrap us up for today, folks. So until next time.